Great. Welcome to House Healthcare. We're back after a short break, and now we're switching gears to look at S89. This is a bill that is currently in judiciary, and it's actually being looked at in our committee. It's going to be looked at in corrections and institutions and potentially in human services without it actually changing jurisdiction, because of timing. So we're going to have Katie do a short walkthrough, and then we're going to take some testimony this afternoon after the floor from Department of Mental Health as to the why this is being put forward. And then tomorrow or Friday, I think we're having Katie come back to walk through kind of our mental health commitment process, because it's something that we haven't really talked to as a group, and a lot of that is in here. So I am going to say I talked to the chair of judiciary this morning, and they are anticipating making more changes, but we're going to walk through with what we have so we can understand the intent. And then, like I said, take some testimony as to the why. And if we have changes, we can provide them to judiciary, and we'll hear about their changes before we take any type of straw vote. Okay.
And that was going to be all we do is take a straw.
Yeah, unless we find something where we're like, we really want to take possession. I think we can do everything we need to do. And if we need to make amendments and then or suggestions to them and then do it as a straw vote.
So there's video.
Right. Yeah. And so this is pertaining to a forensic facility that Katie will go into. This has been a topic of discussion for several years now in the legislature. And so this is a potential solution put forth by the Department of Mental Health. And so I'll just leave it at that. We'll go through the bill and then we'll hear from them this afternoon.
Katie with the Office of Legislative Counsel. So I had anticipated, because the House Healthcare bill is still very much in flux, what I brought in is the Senate bill to sort of give you a basis of the idea that's being considered. And maybe by Friday, we might have some more information about what's going on in healthcare. And at that point, maybe I'll bring that draft. But because it's still in flux, I thought maybe we should just look at what was passed in the Senate, and that would be more straightforward.
Okay.
I do have a section by section summary, so we can sort of look at a high level of what's happening in that bill. Before I open that document, I'll just sort of give you a high level overview. So usually, particularly in this committee, when we talk about persons being committed because of mental health, it's usually they're coming in through what I think of as the civil door. They haven't necessarily committed a crime. They're not necessarily criminally justice involved. But this bill is looking at a different population. This bill is looking at individuals who are coming in through the criminal justice door. So they are alleged to have committed a crime. They may have been determined to be not competent to stand trial. That being not competent to stand trial or competent can change back and forth over time. Somebody who's found not competent to stand trial now in a couple weeks may be found competent to stand trial. But while they're not competent, they need a placement somewhere. And then this bill also looks at individuals who are deemed not guilty by reason of insanity. So their case was adjudicated, and the defense they used was the insanity defense, and that was a successful defense. So what this bill says, those two groups of criminally involved or criminally justice involved individuals, the proposal in this bill is to create a new type of facility called a forensic facility. And basically this bill sets forth the processes by which a person may find themselves in that type of facility. And it looks at the judicial processes involved in moving a person to that type of facility, looks at the admission criteria for somebody being in that type of facility. There's sort of another layer, because this is not just a mental health bill, this is also a disabilities, aging, and independent living bill. So the idea of this forensic facility is that it would be sort of jointly overseen by both departments, meaning the individuals with a mental health concern and individuals with intellectual disability would both be treated, could both be in this facility. In terms of what is the facility that we're talking about? What is the bricks and mortar? The bill specifies that right now the thinking is that one of the units at VPCH, Vermont Psychiatric Care Hospital, would be taken offline. There are currently 3 units in that hospital, and that one of the units would be taken offline, the 9-bed unit. And instead, it would be, instead of being licensed as hospital beds, they would be licensed as therapeutic community residence beds, which is a type of license that Dale manages, and that the facility would be at that unit. The forensic facility would be the unit. The bill does not preclude there being multiple units at some point, or multiple forensic facilities. The way it's drafted, we talk about a forensic facility, not the forensic facility. And also, I think the language gives some flexibility that 4 years from now, the proposal, it no longer makes sense for the forensic facility, a forensic facility, to be at the Vermont Psychiatric Care Unit. There's no language that ties them to being in that unit. The language is flexible, so the facility could be somewhere else at some point in time. So this mostly just creates the legal mechanism, the judicial process to get a person into that type of facility. Good so far? Clear as mud.
So the question came up about whether we lose some kind of Medicaid access because the 9-bed facility would be on the same site as a psychiatric hospital. And I was just wondering about that.
Yeah, so I'll give you a little background, and then I might ask that you bring in maybe Ashley Berliner would be the best person to answer that question. So right now, under federal law, there's this term Institute of Mental Disease, IMD. And in order to get Medicaid reimbursement for treatment at psychiatric hospital, you have to have 16 beds or less. Our hospital has 25 beds. And so we're operating under a waiver for a number of years to be able to get Medicaid for all 25 beds. But the federal government has informed the state that they need to have a plan to start, to stop relying on the Medicaid money for that. In terms of whether taking these 9 beds offline is going to solve that problem, that's a better question for the administration to answer. Talk to them.
There's a phase down schedule that we have to be done with it by 2028, I think.
There is a phase down plan. Yes, I don't know the year. Yeah.
Any other questions right now before we walk through? Okay, I'm speaking.
Okay. Let me share my screen.
Run the summary.
I'm on the summary. I think that might be easier.
Okay, yeah.
And this is all to say that the conversation is evolving in House Judiciary. There are some proposed changes on the table in draft form. There's also, they're taking multiple days of testimony, and I know they're getting new ideas as they, with each witness that comes up. So it seemed premature to sort of bring up what they were thinking. Okay. So this first section is the purpose language that I was mentioning, that we're saying that the purpose of the act is to allow the commissioners of both Dale and DMH to seek treatment and programming of individuals in a forensic facility. And we're specifying that the initial facility will be at a 9-bed unit at VPCH, which will be relicensed as a TCR, therapeutic community residence.
I just ask a quick question there, that only the 9-bed unit will be classified, is that right? The rest will still be correct?
Yeah. So the first part of the bill, the first kind of collection of sections pertains specifically to mental health. I don't think this committee actually is planning to hear about Dale. It's outside of your jurisdiction. Okay. So great, we'll walk through half the bill. So first, we're adding a new definition of what is a forensic facility. It means a residential facility licensed as a TCR for an individual initially committed either under 4822 of the criminal code or 4823. So in insanity as a defense, one applies to persons with a mental illness. The other section applies to individuals with intellectual disability. And these are individuals who are in need of treatment or further treatment in a secure setting for an extended period of time.
Department of Corrections is not involved in this in any way because it's a forensic facility, right?
They're not involved. The custody would transfer and then potentially transfer back again. That's what House Judiciary is looking at, but no.
Okay.
Corrections is not involved in running the facility.
Yes.
You know, when you say an insanity as a defense, sometimes that takes an awful long time. Is there a longevity time period for this or no?
No.
So
It just lets the process happen. Somebody is, incompetent to stand trial, so they don't,
years.
then they are moved, not necessarily to this facility, but this is now an option.
Okay. Oh, okay.
So that process isn't
Okay.
changing, it's
Right.
just
Okay.
where are the options
Yep.
for that person
Okay,
to be
thanks.
placed.
And when it says person with an intellectual disability who has entered this through the criminal, that's it's just not anyone with an intellectual disability, it's only through the criminal process.
Yeah, so the only people who would utilize the forensic facility are people coming in through the criminal door. My term, not the official term.
I just
But I sort of
make sure when
think
I-
of it when, like, the mental health system, you're sort of having folks funnel in either civilly or through the criminal justice system. So these are folks funneling in through the criminal justice system.
And these folks have all been in front of a judge, in front of a jury, and have been
Great question.
found to be this way?
Not necessarily.
Not necessarily, so
So-
they could be held with that as a,
So these are individuals, so we sort of have two boxes. One is sort of the scenario that you're envisioning. So a person is tried for a
Yeah.
crime and they use insanity as a defense. They use
Right.
it successfully. So they're adjudicated not guilty.
okay. And they go in here.
That becomes an option.
Okay.
That becomes an
They
option
can.
if they need further treatment in a secure setting.
Okay,
The other kind of box or group of people are people who have a criminal charge against them. And you have to be competent to stand for your defense. And if a person is not competent to do that,
found to be not competent.
then this forensic facility becomes an option.
Okay,
That's not to say they won't later become competent, at which time the trial would continue, but the trial can't proceed if they're not competent.
didn't we do this, not this particular thing, but we dealt with.
Yeah, S3, it was to put together, I think S3 was to put together a study group, is that right? Or do you want to?
Last year?
No, I think it was 2 years ago. So
2
they
years.
did the requirement in S3 was to do a working group with all these different stakeholders. And I think ultimately that group couldn't really reach a resolution. So this was
Yeah.
the next step that some parties decided to pursue.
Yeah, thanks for that clarification, that's good.
Good memory, Art. Proper, Leslie, Daisy, we're only on the first section.
What I'm concerned about is persons with an intellectual disability. And the staff that's there now, they're gonna be used on this, these 9 beds, right?
I would have, that's a better question for the department. How are they going to do the staffing? And for Dale, are they going to have,
Okay, my point is this, I wanna make sure
Yeah, you
that
can
if somebody goes in there with an intellectual disability, that they get the proper treatment. That's what my concern is.
great questions, much better for the departments to answer than me. I will just tell you at the end of the draft, Senate House Health and Welfare added a language asking for more information about what the staffing and program would look like, recognizing that there are two different populations kind of being served at the same place.
Leslie?
I did read the forensic report, which is available from that study, and it's pretty amazingly I don't know how to describe it, is they couldn't do anything. I mean, it was just really, for want of a better term, well, no, I can't say
Okay,
it.
let's move on.
But it's worth reading. No, my point was that the reason I'm bringing it up is that it's worth reading because it shows the complication of the discussion. That there are just so many people coming from so many different places and that they couldn't come to any conclusion at all, I thought was really interesting. And now we're looking at it again.
Daisy and then Art and then Alyssa, and then we're gonna move on.
My question was about, sorry, I was recently looking for it. Did that get tucked into the big bill that year?
No.
Where did it go? It passed on its own as a standalone?
Yeah. I think it was at least 2 years ago. Could have even
2019.
Was it 2019?
Yeah.
And it's not on the website?
I'll look again.
It would have.
It was
been
like a
the
couple
very
months ago.
End of the bill, I remember. It's one of the last.
If you can't find it, let us know. Alyssa?
I was just wondering if you can refresh my memory from 2 years ago, where are these people now?
Yeah, so they would be in the current system right now. So it depends on if they meet the criteria for hospitalization or treatment in the community. They might be under an order of hospitalization or non-hospitalization. If they're not meeting those criteria, they might be in a correctional setting. For more specifics, I would refer you to the department on that one too.
Okay, let's keep going.
Okay, so we covered the definition, section 2.
We're leaving the house.
So section 3 is a hearing on an application for involuntary treatment. So I will come back, I think on Friday, and I'm going to walk you through in more detail the steps that it takes to have somebody, for example, committed to the custody of Commissioner of Mental Health. Needless to say, there is an application that's filed and then a court has a hearing on the application. So what this language does is it adds a new subdivision that allows either the applicant or the person for whom an order of non-hospitalization at a forensic facility is sought to file a motion for an expedited hearing. So that's also an option for folks outside of this forensic facility process. And this language sort of repeats what is already in statute with regard to a civilly involved population, that the court shall grant an expedited motion if it finds that the person demonstrates a significant risk of causing the person or others serious bodily injury and clinical interventions have failed to address the risk of harm to the person or others. And then language that the court may grant an expedited hearing if it finds that the person has received involuntary medication in the past 2 years, and based upon the person's response to previous and ongoing treatment, there is good cause to believe that additional time will not result in regaining confidence. The reason why this expedited option is important or relevant is because we'll get to a section later on about involuntary medication. There are 6 different avenues under which, or criteria, categories, that if a person meets one of those 6 categories, the commissioner could apply for involuntary medication. So this, having applied for an expedited hearing or being subject to an expedited hearing will be the basis of creating a 7th avenue by which the commissioner could seek involuntary medication of somebody. And then we have a timeline and an extension possibility for that hearing. Next, after the hearing process, the court will make an order. The court will either find that the person does need treatment or doesn't need treatment. There are different types of treatment. There's an order of hospitalization, and that's what it sounds like, that if the treatment is being sought in a hospital, and the court agrees and the person is ordered to hospitalization. This is different. This is an order of non-hospitalization. This is an order that exists now. We're not creating a new order. An order of non-hospitalization, somebody might be ordered to treatment in a particular facility, like the a secure residential recovery facility in Middlesex, or a person could be out in the community but have certain requirements in terms of having counseling on a particular time frame, something like that. So this allows a court to order a person on an order of non-hospitalization to the forensic facility. So we're adding a new subdivision. If the commissioner determines that treatment at the forensic facility is appropriate and the court finds it is the least restrictive setting adequate to meet the individual's needs, the court shall issue an order for ONH at a forensic facility for 90 days, and the court may review the need for treatment prior to the expiration of that order. So that 90 days tracks with what's already in law with regard to orders of non-hospitalization. The initial order is for 90 days, but the court can review it prior to that.
But in current process, the non-hospitalization is actually in the community.
Not necessarily, it could be both, yeah. So it could be in a facility like Middlesex, or there are other types of facilities, but it could be in the community, yeah.
Okay. Art, did you have a question?
Well, I just kind of like what you just asked. Clarification on non-hospitalization. I hear that we're putting this forensic center in a hospital, so we're not talking about that, right? In other words, the forensic facility is not a hospital, correct?
Correct.
Okay.
Yep.
So an order of non-hospitalization moves them to the forensic facility, correct?
Yes.
It can.
It can.
Okay. Because when I hear non-hospitalization, I think, well, we're taking them out of the forensic facility. Because it's
It
in a
is
hospital.
confusing, yeah.
And that's why I asked. the
It's very
question.
confusing.
Okay. Non-hospitalization puts them in, or can put them in
Absolutely, yes. And as this is drafted, it can.
in my head.
Yeah, so an order of hospitalization, you can only be treated at the hospital. An order of non-hospitalization, the options for where you can receive treatment become a lot broader. You could be in the community, you could be living at your home and required to seek treatment. You could be in a group home somewhere. You could be at at the secure residential. And I'm sure the department could come up with 100 other options.
I just wanted to make sure that so I would start, if we're talking about the process and all of that, let's hold the questions for DMH, who will be here this afternoon.
Okay. So that was our order on non-hospitalization. So let's say somebody gets to the end of their initial 90-day order and the commissioner is assessing the person and determines that this person still needs continued treatment. Then we sort of start the whole process again. We have an application for continued treatment. So in that application, if the commissioner is seeking treatment at the forensic facility, they have to expressly state, this is what I'm applying for. I want the person treated on an order of non-hospitalization at the forensic facility. And they have to lay out why they think this treatment is appropriate, why it's the least restrictive setting, and why we can only treat the person safely in this location. And so then the court would have a hearing on this application for continued treatment. And they ultimately make a decision. Yes, the person still needs this treatment, so I'll issue an order of non-hospitalization for a year, up to a year, or no. Even though an order for continued treatment could be up to a year, the person has rights to have that reviewed by a court prior to a year. And that doesn't change from existing law. It just kind of folds into the same process as is in existing law. Next, we have a section on application for involuntary medication. As I said before, there are six situations in which the commissioner could apply to have a person who is hospitalized receive involuntary medication. This bill creates a seventh condition under which the commissioner could seek involuntary medication. This would be the only condition in which the commissioner can seek involuntary medication of a person who is not hospitalized. Is that clear?
If I may? I'm just wondering, so obviously the commissioner can't prescribe. So how does that work? Like the psychiatrist would go to her, or what would be?
So are these questions for DME?
I don't know. I mean, it's the legal, well, I'm only responding to seeking involuntary medication. If you think it's DMH, that's fine. I just don't understand the legality of it.
They would tell you the boots on the ground of how they go about determining what they're recommending, but there's a judicial process. So they're getting a recommendation, from their staff.
Care team, and then that goes to the commissioner, which then goes to the judge.
And then the judge has to make a ruling on whether the person can't be competent to make that decision for the court to order involuntary medication. They become competent in the middle of the order, then the use of the medication has to be discontinued.
Or reviewed.
Discontinued, unless they become incompetent again. So just this new standard that would be put in place, this seventh condition by which the commissioner could seek involuntary medication. It would be an individual's refusing to accept the medication. And it's somebody who's been placed under an order of non-hospitalization at a forensic facility, or the person has an application for involuntary treatment at the forensic facility pending, and the court has granted that expedited hearing that we talked about earlier. So that's the link with the involuntary medication and expedited hearing. And that tracks an existing condition related specific to hospitalization. So far, so good. And then with regard to court findings, we're adding a new subsection that if the court finds that without an order of involuntary medication, there's substantial probability that the individual would continue to refuse medication and as a result would pose a danger of harm to self or others, the court may order administration of medication at a forensic facility up to 90 days or longer if necessary. So that is the order on the application for involuntary medication. And if the individual becomes competent, as I said, the order is no longer in effect. So that's sort of the judicial process by which somebody comes into a forensic facility, is provided continued treatment at the facility or potentially involuntary medication at the forensic facility. So the next several sections are specific to Dale, so I'm going to skip over that.
Do those go to another committee?
So it's great. So next we have language about the certificate of need. This would exclude a forensic facility that's supervised and operated by Dale and DMH from certificate of need requirements. So they wouldn't have to get a CON to operate a forensic facility.
Can I ask some question about that? I mean, CONs come from the Green Mountain Care Board, so, right? I mean, so this would say the Green Mountain Care Board is not involved, or I'm just trying to understand their role, or not.
Well, this doesn't have any role for a certificate of need.
So if you just remove it, then it never goes.
Nobody-
They never even hear about it. That's how that would go.
Correct.
Got it.
Okay, so next we have a rulemaking section, and I would say that this is a piece that is sort of still under discussion in House Judiciary. One draft that I've put together strikes this rulemaking section. This rulemaking section deals with the admissions criteria. What is the admission criteria to the facility and what is the process for admitting somebody to the forensic facility? And instead of having this in rulemaking, it sort of embeds those decision points into this sections of statute we just looked at. So which model they're going to ultimately go with, we shall see. But just to give you a sense of what is in this rulemaking, it would direct the Secretary of Human Services in consultation with the departments to initiate rulemaking by this July. Just to be clear, this doesn't anticipate that they will be done rulemaking by this July, but it just says you have to start it by this point, and the idea is to have rules done before the forensic facility would open, and it's authorized to open on July 1 of 24 in this bill, so it gives a year for that rulemaking process. Specifying criteria that the department shall use to determine admission to a forensic facility and the process used by the commissioners to determine appropriate admissions. Then we have language that admission criteria and processes must ensure that individuals are served in the least restrictive setting necessary. That is to conform with a U.S. Supreme Court decision, Olmstead, which requires that individuals are treated in the least restrictive setting necessary. Individuals' treatment and programming needs dictate that the treatment or programming be provided at an intensive residential level in a forensic facility and individuals only receive treatment and programming within a forensic facility if the individuals have demonstrated a significant risk of dangerousness. The actual language itself in the bill and what is being contemplated downstairs is much more fleshed out than that.
Melanie and then Art.
So you're touching on a question that's been percolating in my brain. Maybe you can help me understand what's the difference of a forensics facility versus like a corrections and hospital. I guess I don't even understand
Sure.
what that looks like.
So unlike a correctional facility, this is more clinical. So the idea is that the person receives treatment or programming specific to their clinical needs. Unlike a hospital is a very specific acute level of care. So these aren't individuals who need that acute crisis level of care that they would receive in a hospital.
Is there special security? I mean, I guess that's.
Yeah, so in the definition where we talk about that the person is being treated in a secure setting. So the idea is that it would be physically secure versus staff secure. So locks on doors, yeah. And then this rulemaking section just prohibits.
Wait, I'm sorry. Art, did you have a question before you?
Well, just quickly before I go, but.
Yep, sorry.
Least restrictive means that I would assume that everybody there is of the same type so that one isn't needing more than, in other words, if one person in that facility needs more security, then it has to go to them, I assume, right?
I'm gonna.
Let
you say that?
Yeah. Sorry. I'm back when you're done.
Yeah, right.
Okay.
Yes.
I have a question that kind of follows from Melanie's, just regarding the setting. It is what are the rules? Therapeutic community setting, locked facility or secure facility, sorry. It's also a clinical setting. Can you help me understand why they don't need a CON?
Because they've exempted themselves from it. I mean, that's why.
Yeah.
Because the bill contains a carve out. You
So
could
and you
remove
can just-
that's a policy decision for us. Yes.
I mean, that's not existing law because we don't have a forensic facility yet.
But what's the requirements
We could pull up,
for a facility that usually requires a CON?
this facility would probably require a CON, even though it's not a standalone facility. It's been a while since I've looked at the statute,
Okay.
but when I was first drafting it, yes,
Normally it
an exemption would be needed for them not to have to go through that
And
process.
let's make sure we ask the DMH as to why they want to carve out.
Maureen?
Could it be because it's already an existing facility? Just going through the CON?
Yeah.
And this might be a better question for DMH, but isn't a certificate of need based on like cost controls and prices? Like, when hospitals need.
And the need.
To justify it.
Yeah, just,
But from a
yeah.
financial perspective, which I can see why this would be exempt from that.
Right.
This isn't
Like
Not
some optional thing, like a spa.
Well, it's a multi-dollar facility because it's already there. But yeah, let's ask the commissioner those questions.
Keep going? Okay. And so there's language in the rulemaking that says until we have these admission criteria rules, we can't admit people into the facility. So that's sort of belts and suspenders. So you have to have the rules in place first. Then we direct the two commissioners to amend existing rules so that they conform with what is being adopted in this bill if it were to be adopted. So Dale would have to amend its therapeutic community residence rules to allow the use of emergency and voluntary procedures, that's restraint and seclusion, and the administration of involuntary medication at a forensic facility. And then DMH would have to amend its rules on the administration of non-emergency involuntary psychiatric medications to allow for the administration of involuntary medication at a forensic facility. So those are conforming changes that would have to happen in statute. And then we have some report backs and presentations. So first, by February of next year, this would require DMH and Dale to jointly present the following information: a plan for staffing and programming, a plan for joint management of the facility by two departments, and whether additional resources are needed. So that sort of gets to the point that Representative McFawn was curious about. And then in section 21, we have a report, an annual report between 2025 and 2030 from both departments. And that would be on the average daily census at the forensic facility, the number of individuals waitlisted and where those individuals are receiving treatment or programming, the aggregated demographic data about individuals served at a forensic facility, and the number and type of emergency and voluntary procedures used at the forensic facility. And then we have our effective dates. So the facility and all of the language that creates a process for somebody to get into the facility, July 1, 24, but we have rulemaking taking effect ahead of that.
Great. Any questions? I'm good.
So you said that judiciary is currently.
We're taking a lot of testimony on it. There's public drafts that I have worked on. A lot of the concept behind the drafts are taking that rulemaking section on admissions criteria and trying to sort of weave that into the statutes themselves instead of having that through rulemaking. I'm not sure where they will land on all of these decisions. So I thought maybe just to give you a high level of what the concepts are would be helpful. And if and when they come out with a draft, we can go through that.
Yeah. And then, like I said, we want to hear from the Department of Mental Health to understand why they're suggesting this. I mean, that's where like our policy comes into play. Leslie?
I'm just curious about the witnesses that are in judiciary, if that's appropriate, right? Because in our area, Windham County, we've had some really terrible things happen. And one of the things the judges talked about was they have no place for individuals to go. And I'm thinking that this facility is hopefully filling that gap. Have judges been part of the witnesses, that system?
I'm not often in the room when committees are taking testimony right now, unfortunately.
Look on the website.
In the committee?
I find it difficult that we don't have possession of this bill. Like, it's a care facility, it's a clinical facility. You know, the issue is one that, I mean, it's a healthcare issue, and it's difficult to not have possession of this and be able to take more rigorous testimony and have more robust debate about it.
We can take as much testimony as we want and have as much vigorous as we want without having possession. So we're going to start with DMH this afternoon and see where that leads us.
Yeah. So
there's no timeline on here, except that if we feel the policy is sound to move forward with the forensic facility, and we want to have that happen sooner rather than later, we want to get it out and get it back to the Senate by the end of the year. But that's a policy, decision we'll have to make.
Where our jurisdiction is the mental health piece, and so if we do a straw vote, we're only voting and talking about that part, right?
Yes.
So that.
Yes. Right. Do we feel that this facility is appropriate for people who come into the system and are under the, Commissioner of Mental Health? We're not focused on Dale.
Right.
We can provide feedback on the rulemaking and process, but the judiciary piece of it really is judiciary.
Dale will do Human Services will do their.
Yeah. That's why it's kind of not moving from committee to committee, because that takes a long time for it to sit on the calendar, but we're all going to take pieces of it. And like I said, Institutions and Corrections is taking a piece of it because they want to understand, okay, well, there's these 9 beds in a psychiatric hospital, but really there's no construction that needs to be done to accommodate this. So they're going to be looking at that piece of it.
So then if there are people that we want to hear from for testimony, we can think that together. As
Absolutely. Yep. Right now, our schedule next week is wide open except for one thing, because I knew, we have a couple of these bills hanging and just wanted to see where our conversation went before we decide who to bring back next week.
Yeah, thank you. This is such a tough issue, and it's something that our system has, looked at, and many of you guys have looked at for so many years, and I just want to do the bill justice and the work that you all have done ahead of us.
So if you have suggestions for people you want to hear from, let me know so that we can get them on the calendar.
So in a way, it may be helpful to hear the history that I think you know really well, but I don't think I know.
Well, we're going to get the history from the Department of Mental Health.
So that's DMH. But will they give us the judicial history? And that's what I'm kind of a little stuck on.
What do you mean by judicial history?
Well, as I was saying that, you know, in our area, judges are saying we don't have a place. So that is what I'm hearing in my area. And I gather that judiciary is taking testimony on that. But would it be helpful to have someone from judiciary come here and help bring us up to their speed?
Well, let's talk to DMH, and if you still have questions after that, because I think DMH is going to tell you the same thing, right?
Okay.
So, and if you have questions after that, yes, we can definitely have someone from judiciary come up and talk about what they're doing.
Okay, that's great.
Okay, any other questions for Katie?
Thank you.
Thank you, Katie, and I know you arranged your schedule, so thank you very much.
Oh, that's okay.
Appreciate it. All right, we can go offline.
Looking at